Right, welcome. I want to talk about the legal implications. Everything legal pertaining Miss Wendy's case. First of all, rest in peace. May her soul find rest with God. It is extremely sad that at this time and age, when in other countries people are doing exploits, we in Nigeria, we are still recording some level of this kind of inhumane acts, rape and murder. However, this video is from the place of people asking me, they've caught these people that perpetrated this act. Why are we not killing them? Why are we not buying them? Why are they still alive? So I told them that this is not how the law works. You don't just because somebody confessed to an offense, condemn the person immediately. Now, the person said he did it, yes, but it is not in the person's place to say he did it. What do I mean? Section 36, subsection 5 of the Constitution, 1999 as amended, the Constitution of the Federal Republic of Nigeria, 1999 as amended. It says something. It said that every person is presumed innocent until proven otherwise. Now, the proving otherwise is done in court. And it is the judge that has the powers to condemn this person. Now, the confession can help the judge. I will come to the ways where prosecution proves their case. The confession is one of the surest ways that can help the judge reach the decision of conviction. Conviction means guilty, you are guilty. Exculpation means you are not guilty. So, this confession might help the judge, will help the judge to reach this decision. But there are still things around the confession that might spoil it. Now, he is presumed innocent. The person that did it, for now, the law says he is innocent. Until when they go to court and the prosecution presents that confessional statement. And if there is no objection, because of course he will still have a lawyer, because this is a capital offense. And even if he doesn't have money to get a lawyer, the state will have to provide a lawyer for him. I have been in a court. I came for another matter. There was a particular murder case, accused or defendant that came out. He didn't have a lawyer. So my lord, that's the judge, chose a lawyer there and then. And you are not, of course, unless you have very enormous reason, like very candid reason, very big reason, you are not expected to refuse the appointment of my lord, because it is seen as a privilege that the judge appointed you to carry on with the matter. But me, the judge actually asked me to do it. I had wanted to do it, but because that court was outside jurisdiction, I told my lord that I'm coming from outside jurisdiction. I can't be coming from my jurisdiction. The transport is too much for me to do a case pro bono. Now, pro bono means for the public good, like free. That's like the best explanation. So when the court appoints you, you're expected to do the matter free for the person. So me, I'd like to do pro bono, but I can't be. The transportation was too much on me, and if it was the same jurisdiction, I would have agreed, and my lord understood. So the guy would have a lawyer. I don't know how many there are. I think there are two. They would have a lawyer or lawyers, depending, to defend them. Now, before that otherwise, I said everybody is presumed innocent until proven otherwise. Now, before that otherwise would be proven, that otherwise must be proven beyond reasonable doubt. That's the standard of proof that the Evidence Act has put. You are expected to prove that this person committed this offense beyond reasonable doubt. And what is the proof beyond reasonable doubt? Proof beyond reasonable doubt does not mean proof beyond every shadow of doubt. As in, there is, if you don't believe it, that means you don't do anything. That everybody must believe it. It is just so true that nobody should doubt. That is not what it is. Proof beyond reasonable doubt is when you say that you have proved a particular matter or a particular offense beyond reasonable doubt, it's saying that you must have led cogent evidence to establish the elements of the offense. Now, that brings me to elements of offense. Every offense have elements. And for you to say that you have proven this case beyond reasonable doubt, you must prove each and every element of that offense. See elements as building blocks of an offense. If you are not able to prove each and every element of this offense, then you have not proved beyond reasonable doubt. If you prove all of them and you fail to prove one, you have not proven beyond reasonable doubt. So you see how the work of the prosecution is a little bit tedious. For example, now let me give an example. Murder. Elements of the offense. If you go to section 316, 317, 318, 319, and all that of the criminal code, the element of murder is summarized as follows. Number one, that the deceased died. You must prove that the deceased died. Imagine if you prove, if you are coming for a murder case and you are trying to prove that the accused or the defendant killed somebody, and you couldn't prove that the deceased died, then you have not even started. That the deceased died, that the death of the deceased was caused by the defendant. The death of the deceased was caused by who? The defendant. This is where most of them usually have problems to prove. And now that the defendant has intention to commit the offense. Now, how does the prosecution prove this case beyond this reasonable doubt? There are three ways that the prosecution prove their case. Number one is by direct evidence of an eyewitness. So, was anybody there to see you when you were doing it? The person would have to come and give oral evidence. Yes, I was there. This was what happened. This was what happened. And that person would now be cross-examined to test the veracity of what he has said. That is direct evidence of an eyewitness. Number two is by circumstantial evidence. Circumstantial evidence. This is not direct evidence. Nobody saw you when you were doing it. But things around you, around that particular circumstance, points to the fact that you were the one that did it. For example, okay, let's use this particular case for example. Nobody saw when he was graping and buying. But earlier that day, somebody saw you around the house, hiding. After about 2 hours, that same person saw when you were running out from the house. As at the same time that it was alleged that the girl has spied. The same time that somebody saw you running away from the house. And when they got to the place of the crime, they now saw your ID card on the floor there. So the evidence of that person that saw you when you were entering and when you were running out, and the evidence of that they saw your ID card at the scene of the crime, points to the fact that you were there. And it is only logical to reach the conclusion that you were the one that bought that. So that's circumstantial evidence. It makes use of what we call the deductive logic. Now we now have the confessional statement, which is what the case here is based upon. Confessional statement. Confessional statement, first of all, is not that video that you watched. Yes, it was confession, but confessional statement is, of course, I am assuming that he must have written it down, that yes, I was the one that graped this Miss Wendy, and I was the one that buyed her. If that confessional statement is brought to court, now, remember now that he was caught, he has no lawyer. When he will have a lawyer, it will be very possible that everything will change. That is why we tell people, especially people that are facing criminal charge, they arrest you. You have your right. This thing that they say you have your right to remain silent, it does not. It is a very good thing for you, because you might say something incriminating. It will not be a problem for your lawyer that will come soon to defend you. You have your right. If they're asking you that question, you have your right to say, I am not talking. I have my right to be silent. Put it to them that you have your right to remain silent. It is your right. As in, your right means it is something that you should stand on. I have my right to remain silent. Now, he was not silent, obviously. He confessed to the offense. Probably he has written it down. Or even he can't write. Of course, his statement has been taken that he actually did it. But that confessional statement has procedures. If the confessional statement is brought to court, and upon tendering the confessional statement, there is an objection by his lawyer. Because of course, the lawyer will have to object. The lawyer will have to defend him. People that are castigating lawyers that will defend this kind of matter. It is their job. It is our job. This is the lawyer that will defend this person. Your daughter will suffer the same fate. Nothing like that will happen. That is the job of a lawyer. Just like it is the job of the police and the Ministry of Justice prosecuting counsel to prosecute. Of course, that's the job of a lawyer. And the fact, even if the lawyer says he doesn't want to do it, the judge will have to appoint another person. So somebody must have to defend him. So when you tender the confessional statement, the other lawyer, the lawyer to the accused or the defendant, will, so accused and defendant, they're actually the same thing. So before it was accused, now it's defendant. So I'm trying to explain most of these words so that you not say you don't understand. The lawyer to the accused can raise an objection, and there are two objections that are usually raised for confessional statements. Number one is, it is not the defendant, I be the accused, that made it. It is not him. Retraction, that's what it's called. Number two, yes, it was him that made it, but it was made under duress. Now, what this particular one might start. Of course, the case is going to court. I am not the judge, but if you look at the video, how his hand was tied at the back, how it was as if they were beating him, he could easily claim that confession was made under duress. Now, if he claims, first of all, if he claims that it was a retraction, it was not him that made the confession, what will the judge do? The judge will accept it, quite all right. But the judge will not attach so much weight to it. In fact, the weight the judge will attach to that particular weight is like W-E-I-G-H-T. The weight the court will attach to that particular confessional statement would now depend on corroborative evidence. That is, other evidence that will support that confessional statement. And so if the prosecution hadn't any other corroborative evidence, that particular confessional statement will be thrown out and the guy will be released. Now, the other arm of the defense is involuntariness. It was made, but it was not him that it was not made voluntarily. He was under duress. That's the second arm. Remember, I said the first arm is what? Retraction. My client did not make that statement, and I've told you what the judge will do. The second one is what? My client made the statement, but he made it under duress. What will the court do? The court will order what we call trial within trial. Now, trial within trial is the name. The trial inside the main trial is to decipher whether that statement was made voluntarily or involuntarily. That's how they will now pause the main trial and go into another trial, calling evidence. Who were there? Who was there when this thing was taken? This statement was taken. They will examine, they will cross-examine, they will just do a full-blown trial in order to satisfy the voluntariness of that confessional statement. And again, confessional statements, section 15, I think, is this subsection 3 of the ACJA and other ACJA's Administration of Criminal Justice Act. Sorry, when I'm talking, I'll be thinking I'm talking to law students because I do a lot of mentorship for law students. So, and I teach on YouTube too. So you can check my YouTube out, the law professor on YouTube. So the Administration of Criminal Justice Act and the Administration of Criminal Justice Laws of each state have said that when you want to record somebody's statement, it must be, in order to prove that it is voluntary, or in order to help you prove that it is voluntary, it was voluntary, it must have to be in the presence of his lawyer or any other person of his choice. And number two, some jurisdiction would now want you to get a videotape of when you were recording the statement. Did you know that in that trial within trial, if that video that we saw, was presented as evidence by the defense, the court would be forced to believe that it was made under duress. You people, there were a lot of crowd there. They were trying. It was looking like someone that they were beating. His hands were tied at the back. That is not how to get confessional statement. And I am thinking, by what I've seen in court over the years, I am thinking that that particular confessional statement might be defenestrated. But I am not the judge. I am not even worthy to tie the shoes of the judge. I'm just explaining. Now, that is that. If that confessional statement is now removed, I'm just assuming it is now removed, then there might be a problem with the prosecution proving this case, because the only way that I think they have planned to prosecute this case is by that confessional statement. Because if you want to talk about, circumstantial evidence. Now, I'm not a biology student. Now, I do not know how long this particular buying took place. In order to prove rape, you know, I told you there are elements to an offense. Number one, that there was penetration. Number two, that the penetration was done without consent. And number three, of course, that the person penetrating had, intention to penetrate and all that. Now, I wouldn't know if there was semen extracted from the of Miss Wendy. I wouldn't know, because normally to prove rape, you must have to extract those semen, test it, compare it to the DNA of the accused. If they did it, very good. That will even place him on in the scene of the offense. But you know our Nigerian police. If they did it, because this is how it is being done. If you're accusing somebody for rape, you extract the semen from the. That's why they say if you're a victim of rape, don't just immediately they finish raping you, you go and wash off. No, immediately they finish raping you, go immediately to the hospital. Explain to the hospital people that, see, I was raped. The hospital people will have a way to extract the semen of the rapist and preserve it, so that when the police is investigating, you can tell them, see, I went to the hospital and they extracted the semen of this person. So that when they now bring the semen and test it against the DNA of the defendant, then my lord will now see that yes, he was the one that actually did it. And so I wouldn't know if they did it very beautiful. That means, of course, circumstantial evidence. It was the semen that was found in the vagina of Miss Wendy. And of course, it goes on to place him, because of course it was after the rape that the murder happened, almost immediately. So it was impossible for another person to come, another different person to come and murder when we have proven that you are the one that raped her. I don't even know whether you're understanding this thing. So, in summary, I've said first of all that every person is presumed innocent until proven otherwise. That is one. And that is to tell you people that are saying, why can't we just stone him to death? No, you cannot. You cannot. You have to allow if we are doing by the procedure, unless you want to do jungle justice, which is, of course, I condemn. Not really condemn, but if you are very sure that this is the person that did it, I support jungle justice. However, the court system is to ensure that fair trial is given, so that justice in the real sense of justice would be done. What is justice in the real sense of justice? Justice in the real sense of justice stands on two pillars. Audio terem patem and nemo judex in casasua. Audio terem patem meaning hear both parties, and nemo judex in casasua meaning no one can be a judge in his own cause. If you uphold any justice that does not stand on the two pillars, then you've not given justice. So you must hear the other party. Then if the other party is coming to say, yes, I did it, then you've heard him and he admitted that he did it. I hope the police doesn't mess this up. Because if the police messes this up and the guy actually did it, and because of the inadvertence of the police, he goes out, it is a problem, because you've released a rapist and a murderer in our society. Thank you.